Welcome to the Extra Mile podcast for bar exam takers. There are no traffic jams along the extra mile when you're studying for your bar exam. And now your hosts, Jackson Mummy and Megan Saya from Celebration Bar Review.
All right. Hey, everybody. Welcome. We're glad to have everybody here with us. We're glad to be here. We are almost midway through November, and we still have some states without bar results, notably California and New Jersey. Very weird. We're going to talk about that in a minute. We're also going to be continuing our series. We've got 3 more questions in our top 10 or 10 hardest MBE questions ever. What do you think? This is pretty crazy of us to do, wasn't it?
Yeah, no, but it's been fun. So hopefully it's helpful for people. Interesting to walk through them. And I'm loving hearing people's reasoning and seeing what other people are thinking about these, because I don't get to sit with students when they do MBEs. We talk a lot about essays, but it's fun to pick their brains about what they think about the MBE questions.
Yeah, and we got a lot of great feedback the last couple of weeks, people saying that they really enjoyed being able to follow along with us as we did the analysis and guess or try to figure out the answers to the questions and then see what the reasoning was and go there. And that's a little different experience than doing it on their own. So we're glad that we could do that. This is kind of new territory for us, but I'm excited about it. We did the series on writing bar essays, the anatomy of a bar essay, and now we're talking about MBEs. So we got 3 pretty tough questions for you today. So stick around and we'll see how that goes. Megan, why don't you kick us off and tell us where we're at and what's going on?
Yeah, wonderful. So we just got a couple more results this week. The last stragglers are starting to trickle in. We got Massachusetts. They had a 19% repeater pass rate. So just continuing that trend that we've seen with these super low repeat pass rates for sure.
Yeah, and there's an old saying, and I'm not sure if it really holds always, that early returns in these situations tend to be bellwethers. You tend to see a trend line setting up. And we saw that trend line going back to the Florida results at about 20% for repeaters. And now it's that trend line is carried all the way through. Every big state has been at about 20%. Few are less than that. Some smaller states obviously could be outliers because they just don't have that many bar takers. But clearly it is, if you're a repeat bar taker, it's a 1 in 5 chance. So this has really been a consistent pattern. Now, I think when we get to California, I don't know, it's such a tough exam. I suspect it'll be even less than 20% for repeaters. And New Jersey, I don't know, Megan, what's going on in New Jersey? What's the deal with those guys?
Yeah, we are still waiting for New Jersey results. It's strange. We should have had them by now. So, and of course, to the surprise of no one, the New Jersey examiners are not saying a word about what's going on or when the results can be expected. So really tough. Hang in there if you're a New Jersey taker. I know this is frustrating. So we'll update you guys when we hear anything. I don't know what's making it take so long this time around, but very unusual. They usually release around the same time as New York, right?
Yeah, and it's a UBE jurisdiction, so it's not like there was something bizarre in the exam. There wasn't. So I'm really puzzled by that and what might be going on there. I just don't know. I mean, it's not like they have 20,000 people taking the exam either. So it's just hard to figure out what the problem was. And again, as you said, they're just not saying anything. So we don't want to speculate. We just don't know. We'll hear soon enough, and just stay tuned. And if you're a New Jersey bar taker, just be ready. So there you go.
We also did get results this week from Rhode Island. They have not released a repeat pass rate, but their overall pass rate was 77%. So
yeah, that would make us think the repeat rate is probably about 20%, because that's really in that range. We're getting low 70s to mid 70s for most states. Smaller states are a little higher. The big states like New York, Florida, Texas, lower still for first-time bar takers. So it remains just a really difficult environment for repeat bar takers.
Definitely. And then, of course, we are waiting on the California results. Those are due out on Friday, and they are always timely. Sometimes crash the website, but always timely. So yes, good luck to California takers who are waiting.
So good luck to everybody taking and waiting for your results. I know it's a stressful time. And this is an incredibly difficult exam. So, just buckle in and see what happens.
Definitely. All right. The other thing we want to talk about, Jackson, are the July 2021 MPTs. You've had a chance now. I know I sprung that on you last time. You've had a chance now to look them over now that we can talk about what they were.
Yeah. The first MPT was asked you as a clerk to a judge to produce a memorandum for the judge identifying the issues in a civil case. And so it's a legal audience with an objective component, very straightforward. And the scores across the country on the MPT reflected that. This particular MPT scored just slightly over 3 on a 6-point scale on average. So most people were okay with it to better, right? It wasn't a big problem. I couldn't quite get my hands, though, on why MPT2 was scoring dramatically lower. And by dramatically, I mean the average was about 2. So it was a very tough question and exam. So I went back and looked at it, and it is a weird hype. It is a document to a non-legal audience. It's to, I love this, it's to a homeowners association board of directors. And I'm laughing because I'm an elected official in a very large, Celebration, which is a very large community. And so the document is to this board of directors, but it's designed to persuade them to do something. So you get what really looks, it's got a non-legal persuasive, but then they give you the form that they want you to use, and it turns out the form is actually objective. So it's state the issue or the dispute, and then give the reasoning, and then show both sides, and then reach a conclusion, which is objective, right? So this problem looks, if I had to categorize it, I would categorize it as non-legal, objective, but it is not a drafting exercise. Remember, we've talked about drafting where you're asked to draft something. You could potentially put it in the drafting category because they give you such an explicit structure of how they want you to write the memo. But it really feels more like you're writing an objective memo, but you can't really cite the law because this HOA board is not made up of lawyers. That's weird, isn't it?
Yeah, definitely.
And I think people probably had some difficulty figuring out how to target and work with that. So I'm going to dig in a little bit further on that. And maybe that's what we should do, Megan, when we finish up the 10 toughest MBEs. We should do some performance test stuff. That would be, that'd be killer. Yeah, that'd be killer. All right, well, there you go. See, so that's how things happen around here. In any event, I think that question was really interesting. It didn't quite fit into the category of a drafting exercise. It didn't quite fit into the category. It certainly wasn't a legal memo with a legal audience objective. And so this non-legal audience objective, but then it felt like at the beginning it should have been persuasive and you have to dig in to figure out that it's objective. That's weird. So I actually think it's a badly written performance test. That's going to get me in trouble with the examiners. I didn't like it. I just thought it was a badly structured question, but we got to be prepared for everything. So there you go. And the scores showed it. I mean, I suspect when the examiners go back and they standardize and equalize the scores, they're going to see it's more than a 1-point difference on a 6-point scale between performance test 1 and 2. That's too much for confidence in my view. So we'll see what happens there. So
great. All right. And our last kind of general info piece is actually someone put this in the chat box as well. News out of Washington State that they have decreased the minimum passing score for the February exam from 270 to 266. And that will apply for anyone who's taking it in Washington State, but also for transfers. So if you're transferring a February score, this upcoming February score from another jurisdiction, UBE jurisdiction, then you'll only need a 266 to pass in Washington State. So good news there.
Yeah, it is. I'm glad to see that. I'm hoping a couple of other states bring their scores down. That 270, 272 is a really high number to hit on the UBE. 266 is the number used in New York, New Jersey, DC, Illinois, most of the large states. So I think it's a legitimate number. So yeah, it's good news. I think there's going to be a lot of jockeying around the UBE, don't you, over the next year or two, as jurisdictions try to decide if they want to stay in, go out, what they're going to do with the new bar exam. So I wouldn't be surprised if we have continual changes in the scoring matrix.
Yeah, it's been interesting because I think Washington State has definitely been a state that's had they've had more flexibility, maybe I should say, than some other states throughout COVID with what that looks like for examinees. So yeah, I think great news if you're taking advantage of it. Take it in February, because who knows if that'll be the case in July. So do it now.
There you go.
All right. Next is, I'm just starting out with a mentor for the Georgia exam. I was not sure if I should schedule an initial meeting to talk and introduce myself or combine it with a writing assignment.
Yeah, you want to take that?
Yeah, sure. I always say it's totally up to the student. So my view is, if you have calls with me, it's your time. So how you feel like you'd like to spend it. Now I'm going to help guide that because I've been doing this a little bit longer than you have. Not you, Jackson, but the student. So
yes. Only 10 years for you, Megan. That's all. You're a baby of 10 years, right?
Yeah. Yes. So, but definitely, I'm always open to meeting with people for that first call. If they just want to talk more generally, that's totally fine. Or if we want to go over a writing assignment, even if we do have a writing assignment, I usually talk more generally for the first call, because we really need to figure out how to do the writing before I start getting into like the nitty gritty of it. Go ahead, Jackson.
Yeah, I was going to say, for some people, what they might want to do actually is do the personal writing workshop with you, right? To get the opportunity to get just the mechanics out of the way before they actually start the coaching. That's an opportunity to do 2 half-hour coaching calls with you before you get into the deeper stuff. And that's a great way to get the mechanics done. And then when you get to the coaching calls, it may be more wide-ranging, right?
Yeah, definitely. But yeah, I think the key is, don't be afraid to schedule that first appointment, which people have been so good. I want to say I'm really proud. I feel like this group of February 2022 students, you guys are on the ball. Like many people are scheduling coaching calls, doing writing workshops, like getting into their studies in a really deep way and consistent way already. So I'm very excited about that.
Well, and I've noticed a lot of people are taking advantage of Brianna's time management workshop, which is a great service that she's offering and we're providing to people. And people come out of that half hour with Brianna and they're all fired up and they got a schedule and then they go do stuff. And I'm seeing the same thing you're seeing. People are really on it. So that's great news.
It is. All right, we had a question just come through in the chat box. I'm going to sign up for photo reading tomorrow. Is this too late for the February 2022 exam?
Absolutely not. Absolutely. I mean, this is the right time to be doing it. It will only take you an hour a day for 8 days. And if you're already in your bar studies, you'll be able to keep going with your bar studies while you're integrating the photo reading. Do the photo reading first if that was because you were brand new to everything. But if you're already in the course, it's no problem. You just do an hour of photo reading and then you do a couple hours, let's say, of your regular bar study. And by about lesson 4, you'll be integrated into photo reading. So it's very simple to do that. And photo reading continues to be the game changer. It's the difference maker for people when we look at scores. Not the only one, but you can tell when people have been photo reading. It certainly makes a difference in their scores.
Great. This one kind of bounces off that a bit. I'm new to the group and the review course I registered last week. Needless to say, I'm a little overwhelmed and nervous. Can you give me any suggestions on how I can get the most benefit out of this course? I'd like to add photo reading, but I'm not sure how it will work for me. Any suggestions?
Well, I'll take the photo reading part, and then Megan, you could take some of the other parts of it. I think photo reading is a fundamental piece of what makes this course work for people. Not everybody uses it, but about 2/3 of our students do. And so I continue to see the results. And I know it's weird and different and it seems very woo and like it wouldn't work, except it does work. And people get these results and they talk about it all the time. And so it's just something I think you should look into and integrate into your studies right away. I think it'll just give you the ability to read an outline in 5 or 10 minutes. It just changes your world, right? I mean, from 10 hours to 10 minutes. It just changes everything. And when you can do that, then it starts to grow and you layer it on and you get better and better at it. And I think it leads to more confidence and more focus as you're studying. So to me, that is primary as a thing to add into the course. Now, as to the rest of it, this feeling of overwhelm and what to do, you want to address that?
Yeah, I think definitely you need to get into a group coaching call. They are included with the course for all of our students. Pick the day time that works best for you. pick the coach that you connect with the most or the group. But I think that is 100% what you should be doing, especially if you're feeling overwhelmed and nervous. Don't go it alone. You don't need to. And you're certainly not the only one who feels that way. Yeah. The other thing I would say is I really recommend doing a personal writing workshop. I think that if you are saying you want to get the most out of this course, I think getting the time one-on-one to make sure that you actually understand FLA writing style is priceless. I just think it's really that is also a game changer, right? Because unfortunately, sometimes people are going down a road thinking, oh, I'm writing it the right way, I'm doing well in it, and no one ever looks at their work, and so they just don't realize where they actually are, right? You don't want the first time that you get your work looked at to be like the exam day. That's my opinion. So I definitely think do coaching with me or Jackson, do a personal writing workshop if you can't do full coaching, but get that feedback on your work. And then the third thing I would say is do mind maps. I think that's the other way to get the most out of this course. You should be doing mind maps. Whether you can do MindMeister, you can buy the mind maps product, or you can literally just take a sheet of paper and a pen and go to town. So it's really very flexible with whatever you need from it. But I think that mind mapping is a key way of making it all come together, in my view.
Yeah. And I'm not aware of any other bar review company that even comes close to discussing mind maps as a note-taking strategy. So this is different for people for sure, but it makes a difference. I think Megan's right about all those things. And if you're feeling overwhelmed, just hop into the course and just go assignment by assignment. Just follow it through. It's all very clearly laid out. I got a lot of feedback this week from people saying they love that it showed the percentage that they had completed. That was interesting to me. That was something that people really responded to, but it's there and it's very simple. And if you just take it one step at a time, it's pretty manageable and you'll get into the pattern pretty quickly.
All right. And our last question before we get into the MBEs. My studies have gotten off schedule. Do you know of a person you can recommend from your program who may be interested in having a study partner as opposed to a study group?
Yeah, we don't do that for a lot of reasons. One is there's privacy concerns. Secondly, we've learned over the years that putting people together, we might think it's a good match, but it's not. And that can cause some problems, right? And everybody's on their own journey. There are different points along the study path. And so some people are far along, others are just starting out, even if they're taking the same exam. So we don't do that. But what we do instead is we offer group coaching, which is an awesome way to get with a group of people, and you'll be able to talk about where you are in your studies and hear from others. I don't think everybody has to be just like you to get the value. And the second thing that we do is that we offer the private Facebook group, and it is a terrific resource to come in and raise those kinds of questions and concerns that you might have and let the community support you. And the community is not just other people in the course, it's people who have passed the bar exam using this course who stay and act as mentors in the site. And man, they are incredible. And the wealth of experience that they bring to this is really something. So I think if you do those things, you're going to be in good shape. The last thing I would say is if you're in a coaching program with me or with Megan, we're clearly going to be watching your pace and your structure and so on. And while we're not peers, our goal is to coach and get you ready for the exam. So take advantage of that as well.
Yes, wonderful. All right, well, let's jump into the MBE questions.
I love that video because I have to say, I felt that way looking at some of these questions as we've been going through, but we are looking at the 10 hardest MBE questions ever. Today, we are going to look at 3 of those questions. We're going to be in 3 different subject areas. And if you're on live with us today, we want you to play along. If you're watching later on replay, by all means, participate. I think you'll get a lot out of this, and hopefully it'll be fun for everybody. So we are going to jump right into question number 5 on our 10 hardest list. So we're now moving to the top half of the list, and I'm going to read the question for everybody, and then we'll talk a little bit about it. So here we go. Question number 5. As Paul, a bartender, was removing restraining wire from a bottle of champagne produced and bottled by Winery, Inc., the plastic stopper suddenly shot out of the bottle. The stopper struck and injured Paul's eye. Paul had opened other bottles of champagne, and occasionally the stoppers had shot out with great force, but Paul had not been injured. Paul has brought an action against Winery, Inc., alleging that the bottle that caused his injury was defective and unreasonably dangerous because its label did not warn that the stopper might suddenly shoot out during opening. The state has merged contributory negligence and unreasonable assumption of risk into a pure comparative fault system that is applied in strict products liability actions. If the jury finds that the bottle was defective and unreasonably dangerous because it lacked a warning, will Paul recover a judgment in his favor? Well, Megan, there's a lot going on there, huh?
There is, yes. But I think if people break it down into a simpler statement, because it's actually not that complicated, but they use a lot of big words.
When we get to contributory negligence and unreasonable assumption of the risk and pure comparative fault and strict product liability, that's all in one sentence. And I think for a lot of people, that's where the panic button hits right there, and then they make a big mistake. That sentence near the end panics you, and then you miss what the actual question is with a huge piece to it. If the jury finds the bottle was defective and unreasonably dangerous because it lacked a warning, right? That should be flashing neon lights or champagne bottles popping in your brain, because that's going to change everything. So let's figure out what to do with this question. You remember that our strategy here is, before we ever look at the answer choices, typically, we want to ask ourselves, particularly in a binary kind of question where there's a yes or no response, how the response would be. So we would ask, would Paul recover in a judgment here? And I think that the first question we ask is, yes, he'll recover, or no, he won't. And I would invite all of you in the chat box to just type in a yes or no. And if you've got a reason, go ahead and type that in, and Megan can share with us what's happening in the chat box. But I've got a reason for asking you to do this. We're going to throw a curveball at you here, but let's go ahead and just ask that question. Can Paul recover a judgment, and see what reactions you get? And are we getting any, are people typing in there, Megan?
So far, we just have one brave soul who has said,
come on, you guys can do it. Don't be afraid. It's good. This is the process you have to go through. You have to first ask yourself this very first question before you've looked at the answer choices. And if you don't do that, it's going to be tough, right? We getting a few more answers here?
Yeah, we're split. I'm seeing yeses.
Yeah. All right, fair enough. All right, so now let's see what happens next. Let's now go and look at the answer choices that we've got. And I think you're going to be surprised by what you see. Answer choice A says no if the jury finds that a legally sufficient warning would not have prevented Paul's injury. Okay. Answer choice B, no if a reasonable bartender would have realized that a stopper could eject from the bottle and hit his eye. A sexist answer. That could have been her eye too. But anyway, okay, you get the idea. Answer choice C, yes, with damages reduced by the percentage of any contributory fault on Paul's part. And D, yes, with no reduction in damages because foreseeable lack of caution is the reason for requiring a warning. Megan, what happens when we get to these answer choices? Did our original structure of yes, no still apply?
Right. So this was so interesting because it flips it on its head. I, like many of you, I read this and thought, okay, yes, I think he's going to recover, right before I saw the answer choices. But then I got here, and what do we see? We have these no ifs and yes with it, which is a very interesting formulation.
Right. And this is what makes the question difficult. It's not the law. I'm guessing that most of you would actually know the law here pretty easily, but the way that the answer choices are presented becomes a problem. So now watch what happens. I now take our yes-no diagram and I now change it to yes with and no if. And what you'll see down here, and hopefully you can read it, is that yes with, reason number one is one of the answer choices. Then yes with, answer number two, right, no reduction in damages. And that's another answer choice. Then we go to the no if the jury finds legally sufficient warning, and no if a reasonable bartender would have realized the stopper could be ejected from the bottle. So now, does this change the way that we approach answering the question? Does this help us?
Yeah, it was helpful for me to think of it. Even though my initial answer was yes, it's not necessarily the way that they formulated the answer choices. So you do always have to be flexible in that way of saying, I might have said a yes in my head, but that doesn't mean that if they give me these yes, if, no ifs, whatever, it might look different than it means the same thing, but be using different words than I thought of in my head.
So now here's our question again. Give you a minute to read the question again. So we've actually analyzed it with a yes, no, and then a yes with and a no if. And now I'm going to show you the answer choices again, A, B, C, and D. And I'm going to ask you, if you're participating with us, to select your choice, A, B, C, or D. So again, you had to decide it was a situation of yes with or no if. All right, Megan, or have we confused people and they're like, oh my God, I don't know what to do now?
We have a lot of C's,
okay,
and a couple B's and a couple D's.
All right, and I will tell you that this particular question, which had a less than 25% correct answer rate over years, has an equal distribution of answer choices. Okay, so
yeah, this is fun because we're very much seeing the same on a miniature scale, the same of a pattern that we see on the macro scale for this one.
Yeah, so let's look at the answer explanations. And of course, the idea here is to say which of those answers most closely matched yours. That's what we wanted you to do. Remember, if it's more than 51%, then you say, yep, I think I'm going that way. So now let's see what we've got. All right, the correct answer was A. Do we have any A's in the board?
We have one. Good job.
Good job. Now you know why this question is so tough. So let's talk about it a little bit. For the plaintiff, in order to recover in strict liability, remember that's what the question asked, the injury has to be causally related to the defective nature of the product. But the question here specifies the product was defective and unreasonably dangerous. That's given to us. And it's not because the stopper shot out of the bottle, but because it lacked a warning. So that subtlety is really important, right? It's what they give you. They say the defect was the lack of a warning, not the fact that it actually causes harm. So in this situation, the plaintiff can only recover if his injury was caused by the lack of a warning. In this situation, Paul was a bartender who we presume has opened champagne bottles. And in fact, the fact pattern tells us that, and observed instances when the shopper shot out with great force. So as a bartender, Paul didn't need a warning on the label. So if you answered A, if you're one of those people, you should pat yourself on the back and say, man, I am smart, because that's a tough question. But let's look at these other answer explanation or answer choices and see why they were wrong. We had some people that answered B, Megan, right?
Yeah.
Okay. So if you answered B, the lack of a warning didn't cause the injury, and therefore he can't recover. And so this choice states the correct conclusion, but for the wrong reason. The lack of a causal connection between the failure to warn and Paul's injuries is the reason that he won't prevail. So here you've got the right conclusion, but for the wrong reason. So I would say it's a close answer if you got B. If the causal connection were present, then the negligence in opening the champagne in this way that caused his injury would not have prevented at least a partial recovery, because the jurisdiction adopted comparative negligence. So you read more about that sentence before the final one, the penultimate sentence, and got probably caught up there. So that's answer choice B. So answer choice C, I think we had a lot of C's.
Yeah, this was the popular one.
Okay. So if there was a causal connection, then this choice would have applied the reduction correctly to the award caused by his comparative negligence because of the law of the jurisdiction that's set out in the question. But again, we go back. It's the lack of a causal connection between the failure to warn and the bartender's injuries. That's the reason Paul will not prevail and why this answer is correct. So that's probably making some people crazy, isn't it?
Yeah, I think this one, it's really interesting. I think if you read the question, which it seems like a lot of people did, you read it and said, which I did as well. I read it and said, okay, yes, I think he's going to recover from this. Yeah, okay. Yeah. So then you would assume then when you see the answer choices, okay, I said yes and C is right. Yes, it's a yes. I said yes. Great. We're good. The thing is, it's the no if is the key. And so I'm so glad we're doing this question because this is something you may see on the exam. If you see the opposite answer that you thought, but it's preceded by an if, that should just make your ears perk up a little, right? Yeah. Because it's telling you, hey, let's imagine something is there's an extra fact here. So in this case, like, no, if the jury finds that the legally sufficient warning wouldn't have prevented the injury, right? So they're giving you another fact. And so you need to see, does that fact change my answer, right? Like, yes, my answer was yes, he recovers. But if I add this fact in, does my answer flip, which is the case here? If it didn't flip your answer, you'd go with C. But if it does flip your answer, then that's how you end up on A. Does that make sense?
Yeah, and that's how bar examiners cause people to have heart attacks, right?
Yes.
I mean, it's a very tough way. Answer D, we've got the same kind of problem. I mean, D is incorrect. It's foreseeable that a person who never opened a champagne bottle might require a warning, but you don't need a warning when it's an experienced bartender. So the lack of a causal connection between the failure to warn and the injuries is the reason that Paul will not prevail. So if you chose answer D, in a sense, you're almost fighting the facts of the problem. So yeah, the real difficulty here is, I think, if you've got this exam, if you've got this multi-state in paper and pencil, I would take the yes with and the no ifs, and I would circle or highlight them in the answer choices so that I'm really aware, hyper aware, that they're saying something different, because those qualifying words are massively important. And
Exactly.
Again, I think most people would know the law here. It's not a question of knowing the law, it's a question of knowing how to answer the question. Okay. All right. So there you go. So now we've probably discouraged some of you, but I think you've learned something, hopefully. We ready to move on? I'm sure everybody's going, oh my God, that was number 5, right? What's number 4? Number 4 is going to surprise you, because look at how short that fact pattern is. In fact, when we first got it, Megan said, where's the rest of the problem? So here we go. At Darrow's trial for stealing an automobile, Darrow called a character witness, Good, who testified that Darrow had an excellent reputation for honesty. In rebuttal, the prosecutor calls Wick to testify that he recently saw Darrow cheat on a college exam. This evidence should be, and that's the question. Now, I don't know about you, Megan, when I see like a 4-line fact pattern, I'm thinking this will be an easy question.
Because you're not going to get mired in the facts like some of the other ones we've done that were really tricky because there was so much to keep track of. But on this one, I think you just have to know the rule.
I think you do. So let's see. Here we go. All right. So should the testimony be excluded? And again, we go to our decision tree before we look at the answer choices. And we would say the testimony should be excluded because, and your reason, or it should be allowed and your reason. So now I'm going to invite you in the chat box, type in excluded or allowed. And if you're brave, give us a reason. And let's see how many of you understand what it is we're looking for here. I'm just going to go back for a minute and show you the question again. So there you go. At a trial for stealing an automobile, he calls a character witness who testified that he had an excellent reputation for honesty. In rebuttal, the prosecutor calls the witness to testify that he recently saw Darrow cheat on a college exam. That evidence should be excluded or it should be allowed. What are we getting in the chat box? Take a guess. And here, if you really feel like you don't know, this is where you just have to trust your intuition, right? What's your gut feeling tell you? Should the testimony be excluded or allowed? I really want you to go with that. And I really want you to start trusting that. And if you're holding back, it's because you're trying to slip from your non-conscious brain into your conscious brain. And you're trying to think if you really know the rule here. And as Megan says, it's going to be important to know the rule. But even if you don't know the rule, I'm going to tell you that intuitively, you're going to have a sense of this. So have I gilded
All right.
Okay.
Yes, we're getting a lot of brave people. I'm really proud. And we're getting both excluded and allowed, and we're getting some rationales. We've got excluded because can use specific instances only on cross. Allowed because the defendant opened the door. Excluded, specific instances not allowed. So yeah, we're...
Okay. All right. So now let's look at our answer choices. Here's our first choice, A. Admitted because Darrow has opened the door to the prosecutor's proof of character evidence. Oh, that's interesting. Okay. B. Admitted because the cheating involves, quote, dishonesty or false statement. And now our exclusions. Excluded is answer C because it has no probative value on any issue in the case. And D. Excluded because Darrow's cheating can be inquired into only on cross-examination of Good. So those are our 4 answer choices, 2 admitted, 2 excluded. So now what you want to do, looking at those answer choices, is find the one that matches up most closely with what you just intuitively thought about the problem. Okay? So take a second, take a look at that. We getting some brave folks out there choosing A, B, C, or D?
Not yet, but I think people are reading through them.
Okay. All right. Fair enough. This one doesn't look hard, does it?
Yeah, I really think this is the rule or you don't the thing.
Right. Okay. So let's see what happens here. All right. We get some people answering.
Yeah, we're getting some A's, some B's, and several D's.
All right. All right. Okay. So again, which answer most closely matched yours? That's the process that we want to follow. Want to make sure everybody is doing that or continuing to do that. All right. So now let's look. If you chose answer A, that was incorrect. The use of character evidence by a defendant permits the prosecution to introduce evidence of the defendant's bad character in rebuttal. I think many of you know that. However, if you introduce it through an additional witness, remember we had wit there, it has to be in the form of either reputation evidence or opinion. What we had here was evidence of a specific act of dishonesty. Remember cheating on the exam, and that can't be raised through the use of extrinsic evidence. So many of you had the right language here, but you can't do it the way that it happened in the fact pattern. So this is a legal factual element, correct?
Yes.
Yeah. So the answer for choice A, people are going, oh man, killer. All right. How about B? If you answered B, that is also incorrect. It's true that the subject matter of Wick's testimony about the college cheating, it's relevant to the issue of the defendant's honesty, and that was raised by the defendant. But again, such evidence can't be introduced by an independent witness in this way. Evidence of specific instances of bad conduct can only be inquired onto in cross-exam. So if you chose answer A or answer B, you're wrong. We had some A's and B's there, didn't we?
Yeah.
Yeah. And again, it's a question of knowing that kind of evidence might be able to come in, but not the way they're trying to present it. So I think you got to know your evidence rules. Answer C, that's wrong. So now the D people are clapping and cheering. Answer C is incorrect because the evidence is probative on the issue of the defendant's character trait of honesty. I hope no one answered C, because I think to me, that's probably the giveaway bad answer.
Yeah, I think that's the one that you look and all the other ones are dealing with a legal standard, and then C seems to be a bit more, I don't know, this doesn't really make sense from a common sense perspective, maybe.
Yeah, and I would think if you were in that realm, answer C doesn't look right to you at all. So what do we got with D? Well, that's our right answer. And the reason it's right is Federal Rule of Evidence 405 limits the prosecution's rebuttal of such evidence through independent witnesses to reputation or opinion evidence, as we said. The cheating issue on the exam could only be inquired into on cross-exam of the defendant's character witness. So did we have anybody answer D?
Yeah, we had several Ds. Good job.
Good job. So when we looked at the distribution of wrong answers, C was not an answer choice that most people chose, but there were a lot of A's and B's. It was actually split pretty equally in people missing because of A and B. So if you were in the A or B, you're with a lot of people, but answer choice D was it. And Megan, you want to elaborate a little bit about this idea of knowing the rule? Some people are going to say, well, do I have to know that it was Rule 405? No,
it's knowing the concept. So my hope, honestly, we talk a lot about, we do the stepped repetition or spiral review. Yeah. And what happens is things like this count as well. Yeah. I can pretty much promise you that if you have actually done this exercise with us, not just listened to it, but you've been an active participant, that if you see a question on the bar that is about bringing in a specific instance of like bad, bad reputation through a witness, you're going to be like, wait a minute, I know this. I remember this. Okay.
Yeah. I think if you're doing your own study and you're in the course, just do word searches for reputation evidence and look at those questions and identify those questions and go through them and look at the answer explanations, because I find that this topic generally in evidence is tough for people. They tend to get really caught up in bad character and prior bad acts, and it all merges together and turns into mush for a lot of people. So it's part of the reason I picked this question. It is a difficult question, but I think it gets at a subject matter that can be hard for people.
Yeah, definitely. And hopefully now it's clear, like whether you got this one right or wrong, the point is, so this is true with all your MBE studies, you now know the concept. And so when you see it next time, you will be prepared.
All right, we're ready for our final question of the day, and it's a doozy. All right, here we go. This is question 3 on our 10 hardest MBE questions ever, so you would expect it to be tough. Plaintiff challenged the constitutionality of a state tax law, alleging that it violated the equal protection clauses of both the United States Constitution and the state constitution. The state Supreme Court agreed and held the tax law to be invalid, and it said, quote, "We hold that this state tax law violates the Equal Protection Clause of the United States Constitution and also the Equal Protection Clause of the state constitution because we interpret that provision of the state constitution to contain exactly the same prohibition against discriminatory legislation as is contained in the Equal Protection Clause of the 14th Amendment to the United States Constitution," close quote. The state sought review of this decision in the United States Supreme Court, alleging that the state Supreme Court's determination of the federal constitutional issue was incorrect. How should the United States Supreme Court dispose of the case if it believes that this interpretation of the federal Constitution by the state Supreme Court raises an important federal question and is incorrect on the merits? A fair number of people just gave up right there in the middle, didn't they?
I hope not, because I actually don't think this is nearly as complicated as it sounds like, which is a running theme with these top 10 hardest questions, isn't it? Like that really it's people tend to, the MBE writers tend to pad it with a whole lot of information or a whole lot of complicated jargon, when really this isn't saying anything terribly complicated.
Yeah, I think by the time we're done with this question, we're going to parse it out so that it won't seem quite so bad. But again, don't be overwhelmed by the question, right? And the language that's in quotes seems very dense and packed, and you might need to slow down and read it a little bit more. But always watch that second to the last sentence. Here it says the state seeks review, saying that their state court determination of the federal constitutional issue was incorrect. Get that fixed in your brain and then go to the call of the question, right? Because the U.S. Supreme Court, how are they going to dispose of it if, and there's that word, if, they believe this interpretation raises an important federal question and it's incorrect on the merits. So now, using our process again, what we need to do is ask whether the Supreme Court should reverse that decision or review the decision. So that's our decision tree here, reverse or review. And that's what I'd like you to write into the chat box. Do you think the court should reverse that decision of the state court or review the decision? And give us your reasons, okay? And
well,
again,
Jackson, can I do a little clarification here on this? Because I think the review sounds like it's saying you would review it to reverse it. So maybe reverse it or refuse to review the decision.
All right, we'll go back. Yeah. So how should the court dispose of the case? So the answer would be they should either reverse the decision or send the decision back to the state court. How's that? Is that better? Okay. So I've got the wrong structure there. Let's see if that helps people. Should the U.S. Supreme Court reverse the decision of the state court, or should they send it back?
And I just want to say again, because I just want to clarify this for people. So I'm like trying to drill this in your heads. This last sentence says, how should the U.S. Supreme Court dispose of it if it believes that this interpretation of the federal Constitution raises an important federal question and is incorrect on the merits? Yeah. What do you guys think? If they're telling you this information, right? We keep talking about this. Notice the same themes come up a lot. This fact pattern is telling you the Supreme Court thinks the state court got it wrong on an important federal question. So right there.
You don't want to go down the path of, the state court got it right, because they're telling you that's not the situation. Yeah.
I'm always harping on this, but using your common sense. If I told you in the world, like just in a regular life, the Supreme Court is mad at the state of California because they think they interpreted an important federal question incorrectly, would you think they're probably just going to send it back to California? Or do you think they would reverse the decision? Yeah. Let's like not forget our normal living in the world experiences.
This question is not about the Equal Protection Clause, is it? Right? They're not asking you to define or analyze that. All right. Well, have we gotten some people brave enough to put in some?
Yes. Yeah, we have.
All right. So let's see what we got here. Here's our answer choices from the examiners. Ready? And I know it's small type, so I'm going to read it. A says to reverse the state Supreme Court decision, reverse that, because the Equal Protection Clause of a state constitution must be construed by the state Supreme Court in a manner that's congruent with the meaning of the Equal Protection Clause of the federal Constitution. That's a very lengthy, wordy answer choice, but that A is reverse. B says reverse the state Supreme Court decision with respect to the Equal Protection Clause of the federal Constitution and remand the case to the state Supreme Court for further proceedings because the state and federal constitutional issues are so intertwined that the federal issue must be decided so that this case may be disposed of properly. That's a mouthful. All right, C, refuse to review the decision of the state Supreme Court because it's based on an adequate and independent ground of state law. So C is a refuse, and D is refuse to review the decision of the state Supreme Court because a state government may not seek review of decisions of its own courts in the United States Supreme Court. Now, I think this is a case where, even though these answer choices seem kind of wordy, they actually help you, in this case, begin to narrow and identify the problem. So A, B, C, or D, take your best guess. We getting some responses?
A couple, yeah, they're starting.
I know some people are just hanging back. They're waiting to hear what we say, and then they
or see what other people say, which I can understand.
Yeah. Okay. All right. We ready to move on?
So let's see what we've got.
There's the question again. So it's up there. All right. I'm going to move on. There's the answer choices again because I know it's tough, but let's see. Which answer most closely matched yours? Again, that's the process. You preview an answer, then you look at the answer choices and you say, what's closest to mine? And I think in this case, it starts to narrow down the problem in a way that makes it, I think, more manageable to answer the question. Are we ready? Here we go. Well, if you chose answer A, I'm sorry, that was incorrect. The state Supreme Court is not bound to construe its constitution in a way that's congruent with the federal constitution. In fact, it's their own document, so they could construe that independently if they choose to do so. So if you chose A, you're just wrong as a matter of law. State courts can interpret their own state constitutions. Does that make sense?
Yes.
Did we have a lot of A's? Hopefully not too many. Okay, all right. So that's why A is a wrong answer. So let's keep going. B was the right answer. So if you were in the A category, you were in the right place, but the wrong time, as Dr. John used to say. Answer option B is correct. Now, even though there are these two distinct equal protection clauses in the question, one in the state constitution, the other in the federal, as we said, the state Supreme Court is not bound to construe its constitution in a way that's congruent with the federal constitution. So if the state court chose to construe its constitution independently of the U.S. Constitution, then the U.S. Supreme Court has nothing to review because the case is decided on adequate and independent state ground. And that language, that term is important to know. But when a state court does what this one did, they construe its equal protection clause, and they said it's exactly the same prohibition, in this case against discriminatory legislation, that exists in the federal Constitution. By doing that, the state court creates a federal question, and therefore they're no longer deciding the case on their independent state ground. So in this situation, the Supreme Court should reverse the decision with respect to the federal part of the Constitution and remand it to the state court. And that's how the Supreme Court gets rid of it. They say, look, you're wrong on the federal question. We know that from the fact pattern. So we're reversing your decision to the extent that you said that you are construing at the state level the federal Constitution. So I think this is where the answer choice really helps work it through. It seems like a logical conclusion. Let me move on to answer C. This was the most common wrong answer. Did we have people that chose C?
Yeah, this was a common guess.
Yeah. So here's why C is wrong. If the state court was going to construe its constitution independently, then the U.S. Supreme Court has nothing to review. Again, the adequate and independent state ground. But because the question said that the court was construing the clauses in exactly the same way, at that point, they create a federal question. And that's what I think people need to recognize, is that when the language says these two are exactly the same, now it becomes a federal question, and therefore it can't be decided on a state ground. It has to be decided on federal ground.
I'm surprised that it's the most common incorrect response and that it was common here today. So people are in good company, but definitely this is, I'm just going to keep harping on it. The question tells you the opposite of this. So don't fight the facts, right? Don't fight them. And we saw it last week too. I think it's a really common thing. This tells you that the court, the U.S. Supreme Court, believes that this interpretation by the state Supreme Court raises an important federal question. Don't fight. That's not there to trick you. It's if they tell you that's a fact in this world, you just have to take it as a fact in that world.
Absolutely. All right. And to wrap up quickly, answer D was incorrect. If a federal question is presented, which it was in this case, then the state has the right to seek a review of an adverse decision of its own Supreme Court. So states always have the right to seek those reviews. So that's the reason D was wrong. If you chose, that's just a matter of law. All right. Let's go back here. That's brutal, huh?
Yeah, I know. These are hard ones. I hope people don't feel discouraged. Obviously, they are just some of the absolute toughest MBE questions. But hopefully my hope is people are starting to see these patterns. The examiners like to write in certain styles, or they put things in, or there's common mistakes that people make over and over again. And so our hope is that you start to see these so that then you can avoid them moving forward.
As we've been saying all along, I think these questions all bring out different aspects of test-taking ability. So we had torts, we had evidence, we had federal con law. All tough questions. We've covered a pretty wide range. We've done some contracts questions, some federal civil procedure questions. And we've done property questions. So next we get the two toughest MBE questions ever. It'd be terrifying. But Megan and I will do our homework and research. We'll be back and we'll talk about that. I hope everybody who participated, I hope you learned something from this process today. If you've been watching on replay, I hope you participated as well, because I do think there's a lot to learn by actually trying and working through this. So hope everybody has a great study week. Good luck to those of you waiting on your California and New Jersey results. And we will be here and ready to help and move on as we get closer to the February exam. Megan, thank you for being here and rescuing me and helping to understand these questions. And yeah, been fun. So we'll see you again next week. The two toughest MBE questions ever. You don't want to miss that, right?
Yeah, I know. Then maybe we should end with like the easiest one ever. Just give everybody a real good boost.
That'd be fun, wouldn't it? Okay, maybe I can do that. We'll do 3 and see how that works. All right. Listen, everybody, have a great week. We'll see you. Thanks for being with us. Bye-bye.
Bye.
Thanks for listening and watching the Extra Mile podcast for bar exam takers at celebrationbarreview.com.